competence of the witness to state in her answers to the questions of the defense counsel.
In other words, the basis of the motion to strike or the object of the motion to strike is the portion of the testimony of the witness on the irregularities.
To the extent of the
Yes.
truth
Yes,
or falsity
yes.
of what was said
And this is
by Justice Sereno in her dissenting opinion. But as far as what Justice Sereno said in her dissenting opinion, it stays into the record as a part of the testimony of the witness.
Yes. We vigorously object to the motion, Mr. President. Firstly, because the dissenting opinion is in fact a matter of judicial notice.
That's correct.
Yeah.
Well, anyway,
and the facts
proceed.
and the facts that are therein stated in regard to the irregularities are part of the opinion of the dissenting opinion. Firstly, Mr. President, these portions of the dissenting opinion are matters stated in opinion by a public official. Therefore, unless proven otherwise, they are entitled to a presumption of truth and regularity.
I'll pose it the question this way, though.
Yeah.
Whether what the witness said as irregular or not, irregular is indeed irregular, they want to be stricken off the record. But as far as the dissenting opinion of Justice Sereno is concerned, what she stated in that dissenting opinion will remain in the record as a part of the testimony of the witness. Am I correct in understanding
That's
your
correct, Your Honor.
position?
We are not in any way disputing the existence of the dissenting opinion, together with what is stated
In other
there.
words, the counsel for the defense said to the court, please disregard the claim of the irregularity attributed to others by the dissenting opinion of Justice Sereno, because the witness was not present when those acts were done and when they came to the knowledge of Justice Sereno.
Well, in which case, Mr. President, these statements in the minority opinion, apart from the fact that they are entitled to the presumption of truth and regularity, the fact is that those statements are in their own right independently relevant statements made by a justice of the Supreme Court who herself was speaking of her own personal knowledge.
Yeah.
Now,
Anyway,
secondly,
this is sufficiently argued. The chair will make a ruling unless a member of the Senate sitting as an impeachment court would want to discuss this matter.
But before the ruling of the Honorable Court, please, is made, may I be allowed 1 or 2 minutes?
I'm not finished.
Your Honor.
I'm
not.
Let us allow the...
Mr. President, I'm not finished.
Yeah, let's allow the
No.
prosecutor to finish.
Secondly, it is plain to us that the motion is actually, in substance, raising an issue either of weight or defense. Now, whether it is a matter of weight or defense, Mr. President, it is not a ground to strike whatever portion of the testimony has been made. If it is a matter of weight, it is for the discretion of the court to decide on whether to give it weight, and if it's a matter of weight, how heavy the weight should be. And if it's a matter of defense, the defense will have its turn to present evidence to impeach, discredit, or overthrow the statements on irregularities contained in the minority opinion. Now, thirdly, Mr. President, I have read the concurring opinions myself, just like the defense counsel, and it is there, Mr. President, shown that these statements on irregularities or disclosures made by Justice Sereno were not treated or met in those concurring opinions. There was silence in their opinions, and we know that as in a court of justice, when such imputations are made, which are serious as against others, there is silence. There is a presumption of truth. I mean, as they say in Spanish, kasi no disputa, se accepta. If you do not dispute, you accept. The other justices never disputed in their concurring opinions these revelations made by Justice Sereno.
If the counsel is true, Your Honor, may I be allowed 1 minute rebuttal, Your Honor?
Just a minute. Is the gentleman from the prosecution true?
Yes, Mr. President.
The defense counsel.
If Your Honor, please, the Honorable Court would notice that we have predicated our motion to strike out on the basis of the admission made by the Honorable Secretary of Justice that she has no personal knowledge of all these irregularities and infirmities, and that this knowledge came to her, by reason of going over the dissenting opinion.
By reading the dissenting opinion.
Correct, Your Honor.
Yeah.
That's why we made the statement that all she testified to in connection with the alleged irregularities or infirmities did not come from her own personal knowledge, but merely from a reading of the dissenting opinion.
That was accepted by the witness.
The presumption of regularity and the fact that the dissenting opinion exists, we never questioned that, Your Honor.
All right.
We never questioned that. We were limiting ourselves to the character of the evidence being elicited from the witness, Your Honor, which in accordance with the evidence and law is decidedly hearsay. And if it is hearsay, then it may be the subject of motion to strike out, Your Honor.
All right.
Mr. President.
Yes.
Mr. President, Senator Miriam Defensor Santiago wants to be recognized.
The gentle lady from Iloilo is recognized.
Before you make the ruling, Mr. President.
Mr. President, I'm responding to your call for the Senator judges, if any, to make an input on this question before you issue your ruling. My first comment is this. Under the complaint, Article 7, the defendant is charged with betraying the public trust, and I'm reading now, quote, through his partiality in granting a TRO in favor of President and Mrs. and her husband, Jose Miguel Arroyo, etc. So the question under Article 7 simply is, did the Chief Justice show any partiality when the temporary restraining order was granted, not by the Chief Justice alone, but by his colleagues in the Supreme Court? That is the question today before us. Now, I have a copy of the internal rules of the Supreme Court. Rule 12 is entitled Voting Requirements and is self-explanatory, and Rule 13 is entitled Decision-Making Process. It appears, from what the witness has said so far, that she has never personally participated in either counting the votes or in the decision-making process of the Supreme Court. In fact, she has said she has no personal knowledge. She has admitted that. Now, according to the Rules of Court, Rule 130 on Rules of Admissibility, Section 36, testimony generally confined to personal knowledge, hearsay excluded. A witness can testify only to those facts which he knows of his own personal knowledge, that is, which are derived from his own perception, except as otherwise provided in these rules. If she was absent, how could she have personal knowledge? What? She is, in effect, therefore, offering to us her opinion. But I've already said several times in this session hall that no opinion is allowed by the rules of evidence unless the expert has first been qualified as an expert witness. She has not been so qualified. She was not present when these so-called irregularities or discrepancies were taking place. So how can she be a witness on this instance, on the particular point of fact of whether the Chief Justice took an active role in issuing the TRO all by himself, when, according to the witness herself, according to the internal rules of the Supreme Court, which are available to lawyers like us, no one justice is allowed to issue a TRO all by himself. So, defense is correct in invoking the hearsay rule. There are exceptions to the hearsay rule. There are 1 to 11 exceptions. Which of these exceptions is the prosecution trying to ground its position on? The general rule of evidence is no hearsay. Only eyewitness can testify except 1 to 11. Under what exception is being quoted? Why are we splitting hairs? It's very, very clear. A witness can only testify as to what he perceived himself, except that there are 11 of these exceptions, and none of them is being cited by the prosecution panel. So in effect, what we have been hearing is a series of opinions extrapolated or explained to us by the witness. But we have already seen that a witness is not allowed to express an opinion unless she has been qualified as an expert witness. And there are rules for qualifying her. Let me quote only one case, just one case, decided only this month, February 1, 2012, the case of Malayan Insurance Company v. Reyes. Here is the Supreme Court. Concomitantly, a witness may not testify on matters which he or she merely learned from others, either because said witness was told or read or heard those matters. Such testimony is considered hearsay and may not be received as proof of the truth of what the witness has learned. This is known as the hearsay rule. Maybe just one other case, Estrada v. Desierto, 2001. But notice that what I cited was a case issued only this month by the Supreme Court, educating all of us in the law profession and in the general public. Estrada versus Desierto. There are 3 reasons for excluding hearsay evidence. 1, absence of cross-examination. 2, absence of demeanor evidence. And 3, absence of the oath. Now, we are talking, the witness insists that her opinions are well-grounded on the dissenting opinion of a singular justice of the Supreme Court. So we are now faced with the issue of what is the weight of a dissenting opinion. The Supreme Court itself said in the 2008 case concerning Mr. Amado Makasait, quote, the Supreme Court stated that elementary decision-making teaches that we cite the majority opinion as precedent, not lonely dissenting opinions. Another case, 2006, JSIS v. Kapisanan. It is the majority opinion and not the dissenting opinion that is the controlling jurisprudence. These are accepted facts in law school. Why do we have to debate these topics? We can safely take them for granted. So to return to Article 7, our quest here is factual in nature. Was the Chief Justice personally and individually responsible for what are perceived deficiencies or irregularities in the issuance of the TRO? The TRO is a subject matter